Good afternoon, everyone. My name is Teresa Lewis. I'm the Director of the Office of the Small and Disadvantaged Business Utilization at the Department of Health and Human Services. I just want to welcome you today to today's training on the 8A Business Development Program, but more specifically, what are the contracting officer's roles when it comes to requesting a waiver from the Small Business Administration, when it comes to requesting sole source set-asides, any letters or requests to remove the procurements from the 8A program. You know, what happens in a basic ordering agreement environment. So we have with us today an expert in that subject area, and her name is Francine Morris. She's a program analyst at the Small Business Administration in the 8A program, the Office of Management and Technical Assistance. And I'm thrilled to have you here. Francine, welcome to HHS.
Thank you so much, Teresa. And it's wonderful to be here and share some of the exciting things that's happening at the Small Business Administration in the 8A Business Development Program.
Fantastic. Well, I will turn it over to you, Francine.
Okay. Thank you.
All right.
I just want to thank everyone for tuning in and becoming a part of getting some instructions on what new things and old things the 8A Business Development Program is providing for you all support. I'm going to go over, I have a little training outline up for you to follow, give you a brief overview of the 8A BD program, offer letters, determination eligibilities, 8A and GSA schedules, contract modifications, contract extension and bridges. How do we look at these things? Competitive requirements, when you want to do a competitive requirement below the threshold, or if you want to sole source something above the threshold. Cure notices, terminations, we're just going to briefly touch all of those things. And then at the end of the presentation, we're going to touch base on the mentor protege program as well as our joint venture program. So the 8A BD program, just a small overview. Our 8A BD program objectives stems from Section 204 Public Law 100-656. And it's there to promote the business development of small business concerns owned and controlled by socially and both economically disadvantaged individuals. We're here to promote the competitive viability of such concerns and to clarify and expand the program for procurement by the United States. In summary, we have a 9-year program, 2-stage business development program providing both developmental, contractual assistance to the firms that qualify for this participation. Moving forward, SBA serves as the prime contractor on 8A contracts. That's on all 8A contracts, and that is something that I do want the procurement community to understand. We're responsible for ensuring the continued program eligibility of the participants. We're going to review all 8A joint venture agreements prior to the contract award. We're going to assist with contract negotiations if it's necessary, and we're going to report and provide, we need you, the community, to report and provide all the copies of the contracts awarded, the modifications, any exercise options, purchase orders. All of those documents should be sent to the Small Business Administration District Office servicing your 8A participant. We need you to know that in order for you to count any contract award dollars as 8A requirements, you must formally offer and accept those. They must be accepted into the program by SBA. So that is something to remember. Talking about offering and acceptance. What I have in the next 2 slides, you'll see what we're looking for when you're preparing an offering to the program. One of the areas, and I'm not going to go through each one of these, but what I want you to do is focus in on number 8 on this slide. 8 says the acquisition history of any of the requirement, including the names and addresses of any small business contractors that have performed this requirement during the previous 24 months. That's a very strong point that we need to ensure that you have all that history into your offering. It's important because, it's especially important because we're looking at adverse impact. And when we're looking at adverse impact, we're looking at if that procurement was formally performed by a small business other than 8A the previous 24 months. And if it has been, then we will have to go through what we call an adverse impact study to ensure that that procurement is suitable to be accepted into the 8ABD program. So there is this myth that we take everything or any requirement can be put into the 8ABD program. We normally have to do an analysis to ensure that that requirement is suitable. And in proper preparing the offering, it allows us to do a proper analysis of an adverse impact, because in the event that it was not properly offered and we didn't know the history and it was accepted into the program, there could be consequences as far as having to remove that work. And so all the work that you've gone through to get the work and award a contract, you could have to start all over. So when preparing these offers, it is especially important that you hit each and every one of those areas that we are asking you to do so. Again, when we're looking at adverse impact, we'll look at last 24 months. If the contractor has been performing the requirement, we want to know if they're currently performing the requirement, or if there's another small business aside from 8A that has performed the requirement in the last 30 days. So SBA will look at those several areas in determining adverse impact. Adverse impact does not apply when the requirement is a new requirement. And if you look in 13 CFR 124-504, that will give you an idea of what we look at as a new requirement. We're looking at the magnitude. If the magnitude of the requirement has changed or adjusted at least by 25%, then we may recognize that requirement as a new requirement, even though it's been performed by a small business other than 8A, a participant. However, remember, and I just want to make a note of this for special note, that if you're talking about combining and consolidating a requirement to show that 25% growth, SBA will in fact, we will take a hard look to ensure that combining, that consolidating is not having an adverse impact on that small business community. So I really want you to pay attention to history. I've found that there has been numerous issues around the agency not providing that history, and it has caused some detrimental impacts as far as getting your solicitation awarded, your award. The next slide, it gives you another, I guess, the other half of what we're looking for in preparing this offering. And like I said, I'm not going to go through each one, but please, when you're submitting your offer to the 8A program, whether it be for a competitive or for a sole source award, please take heed and follow the instructions. There is a purpose for each and every one of these things that we are requesting, and you can look at that at a later date. Where to send the offering letters. When you're offering a sole source requirement, that offer is to a specific participant, 8A participant, to the SBA. It will go to the SBA district office servicing the 8A participant. So if I had a requirement and my 8A participant, their business plan, servicing their district office servicing them, that 8A participant is in Washington, D.C., you would send the offering letter to the district office, Washington, D.C. That's where the firm is being serviced. That's where what they call the business opportunity specialists, that's who will be receiving that offer. And 8A competitive and open construction requirements go to the SBA district office servicing the geographical area in which the work is being performed. So if the work is being performed and it's a competitive construction requirement, the work is being performed in Baltimore, the competitive offer would go to the Baltimore district office. That's where the work is being performed. The competitive 8A requirements and sole source open requirements, other than construction, goes to the SBA district office servicing the geographical area in which the procuring activity is located. So if it's not construction, wherever your procuring activity is, that's the district office you would send your offer letter to. And all 8A requirements to be performed overseas, they would go to my office in SBA headquarters, the Office of Management and Technical Assistance. And we will review those offers for acceptance. Now I want to go a little bit into 8A offer letters and sole source. And I'm just going to dig a little bit into it. Requirements at or under $4 million threshold. The 8A program allows for you to sole source that work to one 8A participant. Now, in doing so, you must make an offer and preparing the offering that we just discussed. It will go to the district office. The business opportunity specialist servicing the 8A participant will look at the offer for acceptance on behalf of that participant. Remember, we are the prime of the contract, and we will accept these requirements on behalf of the program to the contractor. And that's so important for you to understand, because SBA being the prime of the contract is what gives us the authority to be able to speak with the government. Any issues with the contract, we can intervene. So SBA having the prime role in these contracts is what allows us the authority to be able to do all those things in cases if there's any issues or concern. We're going to look at the NAICS code. And when we look at the NAICS code of that offer, we're going to look to ensure that the firm size fits within the NAICS code. So if your requirement is a $7 million NAICS code, then we're going to ensure that the firm is not too large to receive an opportunity within the $7 million NAICS code. We're going to look at the statement of work. And so often we're asked, why do you want to see the statement of work? Well, we want to see a couple things. One, if the NAICS code that you're providing that identifies with the industry fits the statement of work that you have put forth in front and say that this is the statement of work that fits this NAICS code. So we're going to do an analysis. We're going to evaluate it and see if it fits. In addition to your statement of work, we want to make sure that the firm that you have selected as a sole source, if they can truly do the work. Remember, SBA is the prime of the contract. This is an 8A program. We're there to ensure that the firm has the capability to perform, to do the work that's put before them. In other words, if I have a requirement and it is for IT services, however, the firm that you're trying to award this work to does construction. Should SBA be allowed, should they allow the agency to award that work to that construction firm and its IT services? Or are we setting the firm up for failure? And so those are some of the things that we look at when you're sending a requirement that has a statement of work attached to it. Participants current and in compliance with the 8A program. As I stated earlier in our presentation, this is a 9-year program. And we want to ensure that the participant is in compliance to receive the sole source award. Within that, they have annually, our participants have to submit what we call annual reviews. And in those annual reviews, they're providing financials, they're providing updates to their business plan. We're assured that the firm is still in good character, they're doing the things that they should be doing, and they're complying with all the federal regulations. So it is important for us to review the sole source offer. In addition, sole source restrictions. Well, our program initially was a 9-year program. Just flat 9 years, no stages. You'll see that I spoke about a 2-stage program. It's developmental stage, and a transitional stage. Our 8A participants for the first 4 years, they're in what we call the developmental stage. And in those first 4 years, our firms are allowed to receive sole source work continuously. So if requirements come, we're not looking at if they're trying to compete in the small business arena. We're just allowing the firm to receive sole source work continuously. In the 5th year of the program, we call it a transitional phase for the firm. In that transitional stage, our firm is required to do work. At least 15% of their work should be in a competitive, non-sole source small business arena. We're preparing our firms to grow outside of the 8A program. So once they complete their 9 years of the program, they can be a successful small business. With that said, if our firms do not meet the 15% in the 5th year or the 25% in the 6th year of the program, 35% in the 7th year, 45% in the 8th year, nor the 55% in the 9th year of the program. In the competitive non-8A world, we will, what we call, put the firm on sole source restriction. If the firm is on sole source restriction, sole source contracts are unallowable to that firm until they have met what we call their business activity target and met the percentage of work that they're supposed to perform outside the 8A program. No sole source contract awards after a firm has graduated will be awarded. So in the sole source arena, if a firm has graduated the program, they cannot receive that award. And that is even up to the day. So if you start a procurement, your procurement process, and you want to sole source this work to a firm, and they graduate May 14th of 2015, and you don't get anything done, you don't get it done until May 15, 2015, that firm is not eligible for that award. It's not that SBA did not accept it. You may have offered it, and we have accepted it into the program. But until the contract is signed by the government and the contractor, the award has not been made, and SBA will not allow that contract to be awarded to that contractor. So remember that the firm has to be active participant in the program for sole source awards. We have a 5 working day acceptance for those requirements. Determination of eligibilities are done with firms doing a competitive requirement. So if you have a competitive requirement out, our firms bid on that requirement. Prior to you being able to award that contract to the firm, again, you must offer, we must accept it, the competitive, and then you must send the potential awardee to the district office servicing that firm. Okay? You should title the email, because you can send it by email, Determination of Eligibility, and you should attach the statement of work, including the anticipated dollar value of the requirement. We would like to see the base year and the option years dollar values of those requirements. We want the NAICS code and in the statement of work or the body of the email. And we're going to look, because once you have offered and we accepted that statement of work with the NAICS code, we expect for that NAICS code to follow through to award. If there's a change in NAICS code, SBA must be notified that you are changing the NAICS code prior to putting out that solicitation. So any changes, once you offer that competitive and we've accepted that competitive, and you make any changes to what we have accepted, then you must notify us. Because remember, the requirement that we accepted should look the same from beginning to end. We need the original closing date. And I highlight this. And I highlight it because closing dates change of the solicitation. So if the firm is eligible for the award, for the submittal of their proposal, they haven't graduated, and their size, we look at their size when we're making the determination of eligibility. So the firm hasn't graduated the program, and they still fit at May 14th. However, you changed the closing date for the solicitation to May 30th. Well, we look at it, the SBA will say, well, the firm has done all of this work to prepare to make a bid on your solicitation. And now you changed the closing date because of an extension. Well, when we look at the determination of eligibility, we're going to ensure that that firm was eligible to submit their proposal on the original closing date. So we're going to look at the May 14th date, not on the May 30th date. So it's extremely important that the original closing date of the solicitation is included in your determination of eligibility. It protects both you and the firm that has invested thousands of dollars as far as bidding on your requirement. In the body of the email, name the specific firm and the address for us to be able to identify. I now want to turn to basic ordering agreements. In the basic ordering agreement, we have the determination, we have awards that are on sole source basis, okay? And you can sole source a BOA, a basic ordering agreement. However, if you sole source a basic order agreement, each task order requires a separate offer and acceptance. So each task order, you have to give an offer and acceptance. And you say, why? Well, if you're sole sourcing the BOA, the BOAs are not contracts, they're agreements. And our firms have to be active participants for every contract. So once you put the basic ordering agreement in place, if the firm has graduated the program, they're no longer eligible for that requirement. So each task order requires a separate order and acceptance. Each task order is treated as a separate contract, and the aggregate of all the tasks cannot exceed the sole source threshold. So remember, the threshold is $4 million. So if you have a $4 million threshold, you can offer, we will accept those orders against your basic ordering agreement. However, once you get to the $4 million mark, it stops. If the firm graduates the program, it ends, because those requirements, the firm should be an active participant with the basic order agreement, because each one of those task orders are considered new contracts. SBA cannot accept any task orders if the cumulative value of the task orders awarded under the BOA, including all other considerations would exceed that competitive threshold. Okay? So it's important that you ensure that with any basic ordering agreement, you are offering and accepting each one of those requirements are accepted in the program. I want to now turn to GSA 8A contracts. That's the new thing. We've allowed some set-asides for GSA now with the 8A and the 8A arena, and it's been very good for the agency as well as the small businesses that are holding those GSA schedules. There is one GSA 8A contract, and that is the GSA STARS 2 GWAC. That contract was offered as a competitive, and it was accepted into the 8A program. It was a competitive 8A requirement. And because it was a competitive 8A requirement, this GWAC, and it was offered and accepted, we did allow their sole source authority on this particular vehicle. And if you look in 13 CFR 124-503, you'll see where GSA is allowed to make these orders against with their utilizing sole source authority. Please see STARS 2 ordering guide. What I want to say about the GSA 8A STARS 2 contract, if you want to put an order against the GSA STARS 2 GWAC, you must go to GSA. If you want to sole source that requirement against this GSA STARS 2 GWAC, you must go to GSA. You do not have to come to the servicing district office for any requirements put against the GSA Stars 2 GWAC. You go to GSA and they have their own program office that will give you proper direction as far as sole sourcing or doing any competitives against the GSA Stars 2 GWAC. Yes, you will find 8A contractors that have graduated the 8A program that still have a Stars 2 GSA GWAC. Those firms, because it was a competitive 8A requirement, are still eligible to receive, yes, sole source, yes, competitive requirements against the GSA Stars 2 GWAC, because it was, again, a competitive 8A requirement. So that is important to remember. Whereas if the firm graduated the program and you came to the Small Business Administration district office to sole source a requirement, that firm would not be eligible. However, with the GSA Stars 2 GWAC, if the firm is on that GWAC, they are eligible for those requirements. The schedule contracts are a little different. With the GSA schedule contracts, we have set aside authority for those federal supply schedules. Okay, the rule changed in November 2011, FAR case 2011024. Sole sourcing contracts on the GSA federal supply schedule is prohibited. And this is because you have competitive procedures against the federal supply schedules. That is something to remember. Those contracts you cannot sole source an award on utilizing the GSA federal supply schedule. It's very different from the Stars 2 GWAC. It was not competed. You must offer the competitive to the 8A/BD program if you want to use a set aside with the GSA schedules, the federal supply schedules. So you must offer the competitive to the 8A Business Development Program district office. State in that requirement that you will use GSA schedule awards. It's very important that you state in that requirement that you plan on using the GSA schedule. Why? Well, because GSA schedule contracts are not 8A contracts. And because they're not 8A contracts, we need to know what requirements that you put on that schedule as an 8A set aside and what you didn't. Because if down the road we talk about requests for release and we look at the contract and we see it's a GSA schedule, we can't automatically assume now that the contract was an 8A set aside. So if you're going to utilize GSA's set aside procedures and use the federal supply schedules, you must offer it because it's not an 8A contract, and we must accept that requirement. Preparing your offering, just as we discussed earlier in my presentation. Only firms that are eligible 8A holders of the GSA schedule can be awarded a contract on a GSA schedule, federal supply. That is very important to know. Okay, so the 8A company has to be an active 8A participant to be able to compete. In addition, they must hold the GSA schedule that you require them to have, whether that's be the Schedule 70 or the MOBIS. It is extremely important that they have both in order to be considered for the bid. At which point, once we accept that award, you will follow the GSA procedures for the competitive process and award. So at that point, you're going to follow the GSA procedures, and we're going to go through the process as far as their award for that, going through those procedures. Remember, you have to come back to SBA for the determination of eligibility because it is a competitive award, and we need to ensure that that contractor was both eligible 8A participant at the time that you put it out for bid on the GSA schedule, as well as the size they should fit. So you still need to come back to us. So you're using the GSA procedures for your competitive process and pricing. However, For eligibility purposes, Small Business Administration, district office is still involved. Agencies will receive 8A credit for those awards that are properly offered and accepted into the program. Remember, you cannot count the contract award dollars as 8A unless the requirement was formally offered and accepted by SBA. If we did not, you cannot count it towards your 8A awards. Contract modifications versus new requirement determination. Here we're going to talk about, so often you'll come to us, you've put a contract in place and you want to modify that contract. Remember earlier in my presentation, I said that you should be submitting the contract, you should be submitting all modifications, you submit any documentation that we need as far as award of that contract should be at the district office. I know we don't always do that. And those times that we don't, SBA has some issues. We will come to the procuring agency and ask for those documentations, and you've always come through for us. All contract modifications, we require the following info. We need the name and the address of the 8A firm. So we need to know who you want to, what contract you want to modify. We need to know the date of the requirement offered to the 8A program. We need the contract number and the corresponding buyer's number. The corresponding buyer's number is going to be on your acceptance. Every acceptance that we put out, we always have a buy number. That's that number, that requirement number there. That's our buy number. It is extremely important that we have that number. We need to do our research as far as we want to see were there any changes, were there any modifications that we were not aware of. So we're going to go back to the very beginning when we're looking to, yes, accept your modification or negotiate. Maybe the modification can be done, but it needs to be at a lower number if it's an increase in value. We want the original estimated value of the contract, the current contract period of performance, and we want the value, contract dollars obligated and expended to date. Will the dollar value proposed modifications, will it exceed the original estimated value of the contract? We want to know that if that's what you're asking for, and in what event is needed to increase the estimated value of the contract or other modifications. When we're looking at mods, okay, and we're asking for those things because we want to ensure that, I'll give you an example. We have times that we may have a $4 million sole source award. And there are some extenuating circumstances. Maybe for time purposes, you need to modify that contract and you want to add a little bit more money just to give you some time to make your new award. Well, SBA will consider that. We are there to support the community and help you get to your mission. However, we need to ensure that we can work within parameters that we all can live with. So we need to know what was the original amount versus how much are you asking for, and is it reasonable for this requirement, even if you want to extend the period of performance? What's reasonable? Is it reasonable to ask for 30 days or 6 months or, depending upon the size of the requirement, a year? At some times we've been asked for 2 years. You can ask. We're going to look to see if it's reasonable before we approve. Remember, you must get an approval from the SBA district office prior to modifying any 8A contracts. Again, SBA is the prime of the requirement. We need to ensure that all the I's are dotted and the T's are crossed in order to ensure everyone's on the same page as far as modifying these contracts. You cannot just move forward and modify contracts by adding money to them or extending the period of performance on these contracts. Waivers. Sole source above the threshold. What I've done is I've listed some things that we need and what we look at when you want to sole source a requirement above the $4 million threshold. You must get an 8A waiver to do so, and that will be approved by the Associate Administrator at the Small Business Administration headquarters. However, with any waivers, any requests to these for requirements, they should always go through the district office servicing your procurement office. And it is important that you do that, because we do get things at headquarters that we'll go back to the district office. So it'll save you time and it'll save us time if you follow proper procedure and just go to your district office. You go to the servicing district office and you would write them a letter and you will tell them you want to do a sole source above the threshold. We're going to look at the scope, contents of the offer letter. We want all of those usual things need to be put inside this letter. Please look at 13 CFR 124.502. We want a statement of work to accompany it. Please just attach that as a separate document, because we need to look at why you want to sole source above the threshold and why. A thorough explanation by the procuring agency, making this sole source award an approximate amount proposed rather than competitive. Why do you want to go to this one contractor above the $4 million threshold versus putting the work out to all the 8A contractors as an 8A set aside and allow them all to compete for competitive requirement? So we want you to ensure that you have a thorough explanation, because if not, we're going to come back and we're going to ask. Please make sure there's a reasonable expectations. That is, there's not at least 2 eligible 8A participants that can submit for this award. Again, we want to make sure that you should, whenever possible, use the competitive process in order to make 8A awards. So in order for us to entertain sole sourcing above the threshold, it is important for you to ensure that you have all the proper information. We want a written commitment to continue to support the 8A program on a competitive basis when you find practical. We're going to ask you for at least the last 2 recent fiscal years 8A contract dollars that were awarded by the procuring agency, the 8A program participant, on a competitive basis. We want to see that. We want the current fiscal year's forecast to award contracts to the 8A BD program, and the result of any market research conducted by the procuring agency under the NAICS code assigned to the proposed contract. What you don't see on here, and what you probably won't read, is we're going to ask also for a J&A. We want to know, what's your justification of having to sole source this work above the threshold to one contractor? That J&A must be signed by someone of authority to make that call. So we're going to need a higher up, of course, official to sign that J&A as to why you need to sole source this work above the threshold, especially if you're saying it's in the best interest of the government. Why is it in the best interest of the government? And this will ensure that, of course, we have a large small business 8A community, and they are going to, of course, call us all and try to find out why the agency is not allowing full and open competition, 8A set aside for all the companies to be able to compete, and why sole source this work to just one contractor over the $4 million threshold. Of course, as far as the ANC community, the procurement can be sole sourced more than $4 million, up to $20 million without a J&A. But if you went $20 million or more, we require a J&A for you to sole source that work to the ANC community. Competitive requirements below the threshold. Again, you're going to go to the servicing district office. You're going to have the agency's offer letter per 13 CFR 124-502C. We want an explanation of the procuring agency's determination that technical competitions are required or a large number of potential awardees exist. We don't look at competitive requires below the threshold as a bad thing. So often I hear that. That's not what we're looking at. We often see that maybe it is a good idea to compete the requirement below the threshold. It gives the upside. It gives the smaller companies an opportunity to understand how to compete their requirement, how to compete on a requirement, And so it does offer good to small businesses to be able to compete for some of these smaller requirements before they grow larger and have to compete on a larger scale. We need an agency's written commitment to continue to support the 8ABD program on a non-competitive basis below the competitive threshold. This explanation must include the last 2 most recent fiscal years' 8A contract dollars that were awarded by the procuring activity to the 8ABD program participant on a sole source basis. The current fiscal year's forecast to award contracts to the 8ABD program and the results of any market research conducted by the procuring activity. We're also going to ask for dynamic small business searches, results from the 8A firms performing under the NAICS code assigned to the specific contract. District office recommendation will become vitally important to the headquarters when we are asking why should we do this. The 8ABD program participants from the DSBS listing that are qualified to perform the statement of work. Package is forwarded to the SBA headquarters by the analysts with a recommendation to the AABD on whether they agree for a decision to approve or decline the requirement. Again, when we're looking at one other thing I do want to add to this, what probably will be very helpful as well when at headquarters when we're looking at those requirements, is if you include what you have done competitively 8A versus sole source 8A. We looking at those numbers, that if we want to see how well you've done, and we're going to evaluate that as well. So you may get a call back, and we may ask for just a little bit more detail and doing those analysis. So please ensure that you have those numbers readily available, because we will ask for dollars and percent when it comes to when you want to do something, compete below the threshold. It's very important. So often here lately, we've been receiving a lot of requests to release from the 8A program. And so often we hear that it's virtually impossible. Again, another myth. You can request to release things from the 8ABD program. We do look at these things very hard. This is a program that we have worked hard with the procuring committee and community in order to get work to set aside for the 8A to develop these firms within the 8ABD program. If you find that a requirement should be released, you must put in a request to the servicing district office asking for that work to be released from the program. The procuring agency official requests to release on its letterhead. Please put it on letterhead, signed by an authorized person, okay? So often we see these things in the email, and then it just takes time because we send them back. We need you to put it on the agency letterhead, signed by an authorized person that can make the request to remove the work from the program. It should go to the district office. I'll repeat that, because we're going to need a recommendation from your district office as to what they feel, how they feel this requirement should go. Should it be released or should it stay in the program, and why? So the district office, too, has to do an analysis on each of these waivers in order before it comes to the AABD, the Associate Administrator. We need the procurement history. Please make it complete. Please make the procurement history complete. That means if the contract was an 8A procurement and it was only 8A procurement for 6 months, I want to know that. If the contract has been an 8A procurement for the last 20 years, I need to know that. So if the contract was a base year and 5 years, and if you don't know the history, I need you to look for that history, because I'm going to need that history at headquarters in order to make a proper determination of should that work stay in the program or should it not. So please, I can't reiterate on this enough. Make sure that you include all the procurement history. What contractors had it prior to maybe it being 8A? Was it a full and open requirement? Was it competitive? Is there a licensing reason why you want to remove this work? But give me complete history. The NACE code assigned to the requirement. The history of the NACE code. Has it always been one NACE code? Was it consolidated, or did you combine requirements and it went from a service-disabled veteran firm to an 8A after consolidating? I need to know all the NACE codes within that requirement. If the procurement was previously offered to SBA under the 8ABD program, I need the acceptance letter and the SBA's buy number. And I know you'll say, well, you put if the procurement, because sometimes the procurement may not have been offered and you think it has been. So we need to know we need to see the acceptance letter, and we want the SBA buy number. Not all times you have that information, although you should, but not all times you have. But if you give us enough information, SBA maybe can help you find that information needed. So we'll work together to get this information packaged. And that's why it's so important to go to the district office, because remember, the district office is who accepted that requirement in the first place. Okay? Now, the result of any market research conducted by the procuring activity. It is extremely important that you have good market research. Good market research can make a determination of an approval to release the work from the program. But it also, bad market research can stop us from releasing the work from the 8ABD program. Because if you don't have good market research, SBA is going to do their own. We'll probably perform some anyway. But if we can use yours, if it's good enough, we will use your market research as far as seeing if we should move forward. An agency's written commitment to continue to support the 8ABD program. We want full commitment that although you're removing this work, you won't be continuously asking us to remove work. This explanation should include the prior 2 years of 8A contract dollars that were awarded by the procuring activity to the 8ABD program participants, and the current fiscal year's forecast to award contracts to the 8ABD program, plus any additional supporting documentation that will help us make it a consideration. We need you to address the letter, of course, to the SBA Servicing District Office. I want to stop here because I want to discuss a little bit of requests for release. When you request and release from the work, a reason for requesting this release should not be the 8A contractor has graduated the 8A program. Something to remember. These are 8A requirements. They do not belong to a specific 8A participant. We have a 9-year program. The 8A participant has 9 years to participate in receiving 8A requirements. Once they have graduated the program, we would like to reserve those requirements for our other 8A companies coming into the program or currently active in the program. So it is important that if your letter is saying that you want to remove the work because the firm graduated from the 8A program, I can't positively tell you that it will be looked upon favorably. that the work will follow an 8A company or an 8A participant. Has it? There are times that regulation allows us to move work to a company that has graduated in the program. We will look at the detriment on that firm if they're not able to compete for that work. So there are times that we do look at, and we will take it in consideration. And I want to emphasize on the word consider, because you can have all of these things for the above, all of the waivers, but we're still going to do an analysis for consideration on all of the information that I am asking for. So please be sure that when you submit for a request for release, that there is substance there as far as why it is in the best interest of the Small Business Administration as well as your agency to release the work from the program. And other things we may look at is if you have other work that you will be placing into the program. And that's why we're looking at your forecast, because as you're moving dollars out, we may consider releasing the work because you're moving dollars into the program. What I do want to caution you as far as requests for the release from the program, please be cautious not to move work from one socioeconomic group to the other socioeconomic group to the other. That is not why these programs are put in place. We would like for you to, in the beginning of your procurement planning, that you would consider what dollars that you want to set aside for 8A to meet those goals, as well as your woman-owned small business goals, as well as your service-disabled veteran goals and your hub zone goals. It becomes counterproductive moving dollars from SDVOB to 8A to woman-owned, and so we really need you to just do more planning when it comes to those type of activities. Again, for requests for release, there are times that we do release work from the 8ABD program, but we would like a comprehensive document explaining to us why that is in the best interest of both the SBA and your mission. 8A contract cure notices. Again, I do want to reiterate the fact that SBA is the prime contractor. I have been asked often, and so often we've by procurement folks, why does SBA need to know why or if we're going to issue a cure notice or if we're going to terminate a contractor? SBA is the prime on all 8A contracts. With that said, please, when you submit a cure notice to any of our 8A firms, please include SBA on your correspondence. The district office, the business opportunity specialist servicing the 8A participant, should be aware that the firm has been issued a cure notice. And it really does, it will help move the process along if you keep us involved. If we are not notified that a requirement that we have accepted into the program, remember we're the prime contractor, and we're not notified that you're terminating the contract, or if you're moving the requirement, or if you're issuing cure notices to the firm, then we will step in and we will slow your process down, because now we need to know why the firm is being issued a cure notice. We can sit down and we can discuss with you and the firm. Maybe we can come to some resolution early on if we knew that the firm was not performing. So it's extremely important that you keep us involved with any issues that is going on between you and the contractor. The BOS will participate with the 8A firm in the communication with your agency on this issue. Terminations for convenience. SBA district office that approved the offer must also be informed of a termination for convenience, as well as the 8A firm from your agency. The servicing district office must be notified in the event the agency decides not to exercise an option on any existing contract. So even if you're going to not terminate the firm, we need to know prior to terminating. So show cause letters, cure notices, let us know. Get us involved early on. We have actually helped a lot of the 8A participants and the agencies. Maybe there's misunderstanding. We get involved and we help, and maybe we can prevent a termination for convenience or a decision to not exercise an option on an existing contract. Yes, we need to know if you're not going to exercise the option on an existing contract. It could be because you plan on moving the work from an 8A company or move the requirement from the 8A program to maybe a small business set-aside. Maybe you're combining the work. All those things, still, it is important for us to know because there's proper procedures when removing work or stopping work from the 8A BD program. Terminations for default, where SBA is the prime of the contractor for small 8A contracts, SBA must be informed again if the CO has any interest in T for D-ing the company. You must inform the business opportunity specialists. So please make sure that any of these actions, termination for defaults, exercising options, termination for convenience, show cause letters, all of these actions, because we are the prime of the contract, you should always notify the Small Business Administration. I now want to move forward to Mentor Protege program, and I know this was a couple things. This program is a program that we have designed in order to support and enhance the capability of our small businesses. And so the program is here to enhance the capabilities of 8A participants and to improve in their ability to successfully compete on federal government contracts. Our mentors may provide the following forms of assistance to our proteges. They may offer technical and management assistance, financial assistance, including equity investments and or loans, some contracting support, and they may assist in performing prime contracts through joint venture arrangements. And we'll get to that a little later. The benefits of the mentor-protege relationship can include 2 firms approved by SBA to be a mentor and protege. Under 13 CFR 124.520, you may joint venture as a small business for any government procurement, provided that the protege qualifies as small for the size standard corresponding to the NAICS code assigned to the procurement and other relevant program requirements are met. The important statement here is provided that the joint venture it can be a small business, but the firm has to be small for the NAICS code. Not the mentor, but the firm. And as long as the firm is small for the NAICS code and they have an approved mentor protege, then the firm is considered by SBA regulations small for the requirement. A determination of affiliation or control may not be found between a protege firm and its mentor based solely on a mentor-protege agreement or any assistance provided pursuant to the agreement. A contract cannot be awarded, and this is extremely important. We've seen this happen so often, and you've had to start over. A contract cannot be awarded to the mentor and protege based simply on the mentor-protege agreement. In order for a mentor to participate in an 8A contract as a prime with his protege, they must joint venture, and the mentor-protege agreement must be approved before a joint venture can be submitted. So we have the mentor and the protege, they come together. We approve the mentor-protege agreement. It's approved at our headquarters level by the associate administrator of the program, at which point they can then submit what we call a joint venture. The joint venture, you'll find, can be considered it enables the business concerned to carry out no more than 3 specific or limited purpose business ventures for a joint profit over a 2-year period. And this joint venture will start from the date of the award of the first contract without the partners to the joint venture being deemed affiliated for all purposes. Okay? And with this, those firms are able to combine their efforts, their skill, their knowledge, money, property, etc., in order to go after a specific requirement. And this is extremely important. Approved by the SBA, a participant may enter into a joint venture agreement with one or more, so they doesn't have to be 2, just one or more other small business concerns. If it's other small business concerns, then we're looking at the NAICS code of the 2 small businesses. So they must be small for the NAICS code, the 2 firms, for the purpose of performing one or more specific 8A contracts. Remember, in the previous slide, I said that one joint venture, you can be awarded 3 contracts on one joint venture, but it starts from the date of the first contract award. With that said, SBA has to do the eligibility, determination of eligibility for all joint ventures. And we do that because what you won't see, but the firm will be submitting addendums or amendments to their joint venture for each opportunity that the firm goes after. So for each opportunity, they will submit to the servicing district office to be able to compete for that opportunity. A joint venture agreement is permissible only where an 8A concern lacks the necessary capacity to perform the contract on its own, and the agreement is fair and equitable and will be of substantial benefit to the 8A concern. This is important because it has to lack the capacity. Lacking the capacity could mean equipment. It could mean death from in an employment perspective, labor, personnel. So we're looking at, it could be office space. It could be there's a specific location that your solicitation is requiring the firm to be located, and they need to joint venture in order to be in the parameters of where you need them to be. So they must lack something. We're not looking for the firm to have minuscule capability inside of a joint venture. So however, where SBA concludes that an 8A concern brings very little to the joint venture relationship in terms of resources and expertise other than 8A status, SBA will not approve the joint venture arrangement. Again, that means that just because 2 firms submit for a joint venture does not mean that SBA will approve that arrangement. Okay, so remember that it is important that when we see 2 firms come together, that they are actually, the 8A firm is actually lacking something within that procurement, and it's not there just because they're 8A, and a larger firm or another small business wants to compete with them just to be able to compete in the 8A community for work. Our joint ventures come into 2 forms. We have what we call populated joint ventures and unpopulated joint ventures. And because of that concern, I do want to put out to the community that when you're allowing joint ventures to be a part of to compete on a requirement, you should take in consideration that when they submit their proposals, that they are submitting whether or not the contract will be, the joint venture that they are involved in will be a populated joint venture or a unpopulated venture entity. And in these slides, you'll see what we have, the difference in those. Unpopulated joint ventures are populated only with 1 or more administrative personnel. The project manager is an employee of the 8A managing venture. And remember, there must be more than an administrator or ministerial orders to gain substantive expertise. We're looking at the performance of work by the 8A contractor, include those mentors and proteges authorized by 13 CFR 124-520 when we're looking at large business ventures. We're looking at the work required, and the joint venture must perform at least 40% of the work. And so you'll see just a little bit more detail that I've given you within the joint venture community. Please, again, we need you to submit for a joint venture, as far as award of a joint venture, any 8A determination of eligibilities. Can you sole source to a joint venture? The answer is yes, you may sole source to a joint venture. Remember, you will follow the same procedures of offering and acceptance, and we will go through the determination of eligibility if it's a competitive requirement. I thank you so much for giving me an opportunity to present to you, and we'll move forward with any questions that we may have.